Good morning, everyone. Honorable Justices of Appeal, Judges and Masters of the Eastern Caribbean Supreme Court, Their Excellencies, Heads of State of the OECS member states and territories, Heads of Government of each of the OECS member states and territories, the Honorable Dr. Irvin McIntyre, representing the Honorable Prime Minister of Dominica, Sir Brian Alleyne, retired Chief Justice of the Eastern Caribbean Supreme Court, and Lady Alleyne, Her Ladyship, the Honorable Justice Wainante Roberts, and other retired judges of the Eastern Caribbean Supreme Court, the Honorable Levi A. Peter, Attorney General of Dominica, and the Honorable Attorneys General of the other OECS member states and territories, Honorable Ministers of Government of Dominica, and the Honorable Ministers of Government of each of the other member states and territories, Permanent Secretaries of the Ministries of the Commonwealth of Dominica, and Permanent Secretaries of Ministries of Government of the other member states and territories, Parliamentary Secretaries in the Ministries of the Government of Dominica, and the Parliamentary Secretaries in the Ministries of Government of the other OECS member states and territories. Her Honor, Mrs. Candia Carrot George, Chief Magistrate and Magistrates of Dominica, and other Chief and Senior Magistrates and Magistrates of each of the other OECS member states and territories, Speaker of the House of Assembly and President of the Senate of Dominica, and Honorable Speakers of the Houses of Assembly and Presidents of the Senate of each of the other OECS member states and territories, Leader of the Opposition in Dominica, and leaders of the opposition of each of the other OECS member states and territories, members of the Dominica House of Assembly and Parliament, and members of the Houses of Assembly and Parliaments of each of the other OECS member states and territories, His Excellency Dr. Didicus Jules, Director of the OECS Commission, Ms. Sherma Dalrymple, Director of Public Prosecutions in Dominica, and Directors of Public Prosecutions of the other member states and territories, Mrs. Tamika Burton, Solicitor General of Dominica, and Solicitors General of the other OECS member states and territories, Mrs. Michelle John Tibbles, Chief Registrar, and Mrs. Danelia Chambers Sylvester, Deputy Chief Registrar of the Eastern Caribbean Supreme Court, Ms. Nuraya Sebastian, Acting Registrar, and Ms. Kayan Toussaint, Acting Deputy Registrar of the High Court of Justice Dominica, and Registrars, Deputy and Assistant Registrars of the High Court of each of the other OECS member states and territories, Mr. Gregory Gerard, Court Administrator, and Mr. Francis Letang, Deputy Court Administrator of the Court's headquarters of the Eastern Caribbean Supreme Court, and Court Administrators of each of the High Court offices of the OECS member states and territories, Mr. Delano Bart, KC, President of the OECS Bar Association, Mrs. Noelise Knight Didier, President of the Dominica Bar Association, and Presidents of the constituent bars of the other OECS member states and territories, members of the clergy, members of the diplomatic corps, Commissioner of Police and Deputy Commissioner of Police and Assistant Commissioners of Police of Dominica, and Commissioners of Police, Deputy and Assistant Commissioners of Police of the other OECS member states and territories, Mr. Wayne Letang, Chief Fire Officer of Dominica, and Chief Fire Officers and Deputy Chief Fire Officers of the other OECS member states and territories, Mr. Jeffrey Edmond, Superintendent of Prison, Mr. Alvin Ogist, Assistant Superintendent of Prison of Dominica, and superintendents and assistant superintendents of the other member states and territories. Members of the media, specially invited guests. And I think the protocolist, I have to apologize, I have left out members of the bar. And not only members of the Bar of Dominica, but members of the bar of all of the Eastern Caribbean states and territories. Good morning again. Emerging from a strong and proud and storied history that has shaped its prestigious present, today, the Eastern Caribbean Supreme Court advances towards its venerable future as we formally mark the opening of the law year 2026. On this momentous occasion, heralding the approach of the court's 59th anniversary, we celebrate much more than the commencement of another judicial cycle. Rather, we collectively pause to reflect, to take stock of who we are as an institution, and more importantly, who we must continually strive to be. Reflecting thoughtfully and honestly on the collage of complex challenges, surmounted obstacles, and distinguished achievements, and meaningful contributions of the ECSC, properly positions us to plan and act intentionally to maintain that which we have built and to expand on it. The legacy of this institution has been memorialized annually through this ceremonial special sitting by stalwart figures who have preceded me. And so, it is with a profound sense of humility, honor, and privilege that I carry on that tradition by addressing you for the first time as Acting Chief Justice. In recognition of that legacy today, I wish to focus on the enduring spirit of the ECSC, one that has remained steeped in the principles that underpin justice. It is therefore fitting that the theme for this year's observance of the ceremonial opening of the law year is the ECSC, justice that endures, anchored in independence, strengthened through trust. This theme not only encapsulates the indomitable spirit of our great court and its unwavering protection of and adherence to the rule of law, but also it reinforces the integral and symbiotic relationship between the judiciary and the public, affirming that the integrity of our justice system is sustained not in isolation, but through institutional responsibility bolstered by public trust. When we speak of judicial independence, it is commonplace to focus on the more visible mechanisms designed to insulate judges from external pressures, whether arising from the government, the public, or private interests, in order to secure impartial and principled decision-making. These mechanisms include constitutional guarantees of an independent and impartial judiciary, institutionally distinct from the executive and legislative branches, security of tenure for judges, and safeguards relating to judicial remuneration, intended to preserve the judiciary from inappropriate financial influence. However, judicial independence is not static. It must be continually defended, actively exercised, and carefully preserved. And so, the judiciary's independence must also be sustained by the institutional frameworks and professional culture it cultivates. Frameworks designed to embed transparency, to ensure accountability, and to safeguard the proper administration of justice. Beyond what is constitutionally guaranteed, it is the active and conscientious exercise of the judiciary's institutional responsibility that nurtures public trust, without which the authority and legitimacy of the court cannot endure. It is through this dynamic, justice anchored in independence and strengthened through trust, that the promise of justice endures, giving full expression to the theme for the opening of the law year this year. Over the past year, the ECSC has continued to deliberately build upon its institutional frameworks, guided by a clear objective: to enhance the effectiveness, efficiency, and overall quality of justice delivered to the people of the Eastern Caribbean. These efforts have been strategically directed towards technological and infrastructural advancement, procedural and policy reform, capacity building, and meaningful community outreach. They reflect a holistic approach, accompanied by the recognition that justice which endures must be supported by systems, infrastructure, and practices that are responsive to contemporary demands while remaining faithful to the court's constitutional mandate and its core values. By now, most of you may be familiar with the ECSC's ongoing pursuit of institutional strengthening through technological innovation, geared at improving the accuracy, timelines, and accessibility of our court. Last year, you were apprised of a new artificial intelligence transcription service, FTR Justice Cloud, for which we commenced installment in early 2024 in courtrooms across several of our member states and territories. I am happy to announce that the ECSC has embarked upon procuring an upgrade of the FTR Justice Cloud service, which will significantly advance the court's recording and transcription capabilities, enhancing both the reliability of our records and the efficiency with which judgments may be produced. Such improvements directly support a timeless and transparent administration of justice. In keeping with global developments, the court intends to explore further responsible uses of AI within the courtroom and in judicial administration. Recognizing both the benefits and risk inherent in these emerging technologies, the court is now developing a formal policy to govern the use of AI by judges and practitioners alike. This policy is intended to promote the reduction of certain administrative and routine tasks that clutter the administration of justice, while safeguarding the independence and fairness of the judicial process. The ECSC is committed to ensuring that technology remains a vital tool in the service of justice, not a substitute for judicial judgment or other ethical obligations attendant to the legal profession. The court intends to undertake a comprehensive revamp of its website, to introduce new software designed to improve functionality, accessibility, and ease of use. In an era where the public increasingly engages with public institutions to ensure access to information through digital platforms, the court's online presence is an essential gateway to information, services, and public understanding. Having a modernized and easily accessible digital platform strengthens the court's communication with the public, improves public access to court resources, and reinforces the court's commitment to transparency and service. Of course, the ECSC's greatest technological achievement thus far has been the completion of the e-litigation portal project. It has been over a year since the ECSC has achieved the full onboarding of all types of cases onto the ELP, marking a critical milestone in the pursuit of a more streamlined and uniform case management system. Thus far, I have been made aware of challenges faced by the court staff in their interface with the platform, and our information technology department is actively working to resolve these challenges. Equally, the court relies on feedback from other stakeholders to assess the platform's efficiency for litigants. However, the full potential and usefulness of this innovation cannot be realized without the full cooperation and the participation of the legal practitioners who are its main users. As with any technological system, full and consistent engagement by its users is the touchstone that informs the need for future recalibrations or upgrades. And so, I take this opportunity to urge all legal practitioners to be guided by the e-litigation portal guidelines document found on the court's website and complete the migration of all their matters onto the ELP so that the system may function in the way it was intended, to promote consistency, efficiency, and more timely resolution of cases across the jurisdictions of the court. Equally significant has been the court's infrastructural advancement. Late last year, after a long and arduous process of almost 2 decades in the making, the ECSC finally acquired a headquarters building, purpose-built to meet the evolving needs of a modern and regional judiciary. This long-awaited development has provided us with a singular location that houses fit-for-purpose courtrooms, that is, a grand courtroom and 2 smaller ones, that caters to the infrastructural and resource needs of the court staff to enhance productivity, collaboration, and service delivery. I must express my heartfelt gratitude to my 2 immediate predecessors, the Right Honorable Dame Janice M. Pereira, retired Chief Justice of the ECSC, and the Honorable Mr. Mario Michel, retired Justice of Appeal and the immediate past Acting Chief Justice of the ECSC, whose steadfast leadership, vision, and dedication was instrumental in bringing the procurement of these new headquarters to fruition. I wish to also echo the sentiments equally expressed at the ceremony commemorating the official handover of the headquarters in November 2025 by thanking the government and the people of St. Lucia for this tangible investment in the administration of justice and in the people who labor daily to uphold it. The new headquarters serves as a shining example of the formulaic endurance of justice. It is a powerful symbol of a people's trust in the judiciary and their continued affirmation of the court's legitimacy to discharge its institutional responsibilities in the administration of justice. It is my sincere hope that this trajectory of infrastructural advancement will continue for the ECSC across all member states and territories, and will ultimately result in the provision of fit-for-purpose courts and the proper halls of justice across the jurisdiction. I am pleased to note the ongoing Halls of Justice project in St. Lucia that is projected to provide a complex which will consolidate all civil, commercial, criminal, and family courts with support services such as mediation for both the High Court and Magistrates courts under one roof, with a completion date expected in 2027. Alongside the prior mentioned infrastructural and technological advancements, the ECSC has continued to pursue effective procedural and policy reform aimed at strengthening the administration of justice across the member states and territories within the bounds of its constitutional role. While the judiciary is not a maker of legislation, it bears the solemn responsibility to apply, interpret, and enforce the law in a manner that promotes fairness, efficiency, and justice. It is in this context that the court has advanced these reform initiatives, including those geared towards modernizing trial processes. As an example of this, the introduction of judge-alone trials in criminal proceedings. Judge-alone trials have already commenced in a few of our member states, namely Antigua and Barbuda, St. Kitts and Nevis, and St. Lucia. We anticipate that the use of judge-alone trials will further streamline and increase flexibility in criminal proceedings. We also expect a significant reduction in the criminal case backlog, as the process is set to eliminate delays associated with jury selection and management, ensuring a timelier resolution of cases while preserving fairness and due process. I look forward to seeing the process being adopted further in the remaining states and territories. Complementing this initiative is a comprehensive revision of the criminal procedure rules, which have now passed the final vetting stage and are poised to be promulgated before the end of the first law term. I pause to thank the judicial officers and legal practitioners who form part of the committee that diligently toiled over these revised rules. I would like to especially thank Justice of Appeal Trevor Ward for chairing the committee and guiding it towards its intended objectives. The court has also prioritized the expansion of its use of ADR within the criminal justice framework through its soon-to-be-issued Criminal Mediation Practice Direction. This practice direction has been completed and has been sent out for public comment, an important and necessary step toward embedding structured mediation into appropriate criminal matters. Additionally, work is underway on the amendments to the sentencing guidelines aimed at promoting consistency, transparency, and fairness in sentencing outcomes within the court's various jurisdictions. With those reform initiatives in mind, it would be remiss if I did not take this opportunity to urge the member states and territories which have not done so to attend to the establishment and effective operation of their respective Needham's Point Declaration committees. The Needham's Point Declaration continues to serve as a guiding policy framework for addressing systemic changes within our criminal justice system. The committees are therefore integral to the effective implementation of policies and reforms envisioned therein. Only through sustained collaboration and shared commitment can the objectives of the declaration be realized, making way for lasting progress through a holistic approach to criminal justice administration. It is in furtherance of the objectives espoused by the declaration that the ECSC, with the kind assistance of the PACE Justice Project, hosted a criminal backlog symposium in October 2025 that brought together key justice sector stakeholders to examine the causes of the delay and to identify practical, lawful solutions consistent with the policies set out in the declaration. It is my sincere hope that the works of these committees, like the Criminal Backlog Symposium, dedicated to confronting and solving the challenges faced by the criminal justice system, will continue to flourish. The ECSC has also continued its commitment to capacity building, recognizing that the strength and credibility of the justice system ultimately depends on the knowledge, skills, and professionalism of those who serve within it. As is customary on its calendar of events, the ECSC, through the Judicial Education Institute, hosted the annual Judicial Conference 2025 last September, convened under the theme of criminal law. The conference provided an important forum for judicial officers to engage critically with evolving legal principles, procedural developments, and best practices, thereby strengthening judicial competence and consistency in criminal law across the region. Including in the agenda of the conference was a focus session on judge-alone trials, and the court intends to expand on this by hosting further targeted training to strengthen judicial capacity and confidence in the effective implementation of this newly introduced process. The court has also deepened its commitment to legal education and mentorship through its collaboration with the Hewarding Law School through a legal aid initiative that was conducted throughout the last court term. This initiative was aimed at enhancing the legal aid experience of the Eastern Caribbean students at the law school by exposing them to the realities of legal practice in the Eastern Caribbean through direct engagement with the court, complemented by structured sessions led by court officials who shared practical insights drawn from their professional experience. Such exposure not only enhances legal training, but also fosters an early appreciation of professional responsibility, public service, and the judiciary's central role in upholding the rule of law. Importantly, this collaboration operates as a form of forward-looking capacity building, with the potential to cultivate a future pool from which the court may one day draw its legal professionals, thereby allowing the institution to play a constructive role in the shaping of standards and the ethos of those who will serve the justice system in the years to come. In the spirit of looking ahead, the court also intends to expand its judicial training in the area of family law, with the express objective of strengthening and establishing family courts in the jurisdictions where none exist presently, beginning hopefully with the Commonwealth of Dominica and Grenada. This initiative reflects an understanding of the specialized and sensitive nature of family matters and the need for judicial officers to be equipped with the requisite expertise to address them effectively. Additionally, the court plans to enhance its institutional analytic capacity through the strengthening of its statistical unit, thereby improving data collection and analysis to better inform policy decisions, resource allocation, and strategic planning. You will agree that capacity building must also extend beyond the bench to the bar. In this regard, I urge the court's constituent Bar Association to give consideration to making continual legal education compulsory as a means of maintaining professional competence and raising the standards within the legal profession. I further exhort counsel across the region to recommit themselves to the highest ideals of advocacy, integrity, and service, and to play their part in restoring and preserving the nobility of this legal profession. A strong, ethical, and well-prepared bar is indispensable to the effective administration of justice and to the public's continued confidence in our courts. Building on the brainchild of our immediate acting past Chief Justice, the Honorable Justice Mario Michel, the ECSC has remained steadfast in its commitment to community outreach and public education. We recognize that an informed public is essential to sustaining confidence in our justice system. Early last year, prior to his departure in May 2025, Justice Michel completed the circuit of school visits, which were designated under the court's public education program. Through these school visits, the former acting Chief Justice was able to engage directly with the students at the remaining community colleges in Grenada, St. Vincent and the Grenadines, and the British Virgin Islands. These visits provided invaluable opportunities for dialogue with the youth of the Eastern Caribbean and encourages civic awareness and interest in public service and the administration of justice. The court has also sustained its public lecture series as a platform for meaningful and thoughtful discourse on various legal issues of social importance. The most recent lecture in November of 2025 was held in Antigua and Barbuda and was delivered by Mrs. Shannon Jones-Gittins, the island's Director of Public Prosecutions. Her contribution on the topic of the impact of criminal court backlogs in the Eastern Caribbean Supreme Court, transforming challenges into opportunities for change, enriched public understanding of the case backlog challenges faced by our criminal justice system, and hidden opportunities to fix them. Later this evening at 6 p.m. at this same venue, the court will be having its first public lecture for 2026 under the theme Estate Planning and Access to Justice. This lecture will be delivered by His Lordship Justice Alvin Parry-Axing, High Court Judge assigned to St. Lucia. We invite the public to tune in via the court's website and the UETV website and Facebook page. Building further on our existing initiatives under the public education program, the court will be hosting a public exhibition designed to enhance the public's knowledge of the court's rich history, prominent figures, current processes, and reform initiatives. It is hoped that this will foster greater transparency and strengthen public engagement. The court intends to work with the Justice Education Society on the development of a 5-year strategic plan to guide its community engagement and institutional development initiatives. Of course, we intend to provide you, our stakeholders, with various updates via our court's website and its social media platforms as these plans are implemented. Our social and institutional responsibilities are, however, not restricted to the service of our own jurisdictions, but extend to those who play a role in the development of the wider Caribbean jurisprudence. I am happy to announce that the ECSC, being headquartered in one of the signatories of the Caribbean Court of Justice, will have the honor of hosting this year's special sitting to mark the opening of the CCJ's law year in October. This underscores this court's commitment to regional judicial cooperation, and I look forward to this auspicious occasion. In further keeping with its regional responsibilities to its wider judicial family, the ECSC will also be engaging in fundraising and donation procurement to support the relief efforts in Jamaica following the devastation caused by the passage of Hurricane Melissa. The ECSC is no stranger to the concept of regional unity, and therefore we will step in and extend our support to our sister jurisdictions whenever they are in need, whether by cause of ceremonial observation or devastation. While this address cannot fully encapsulate the breadth of the court's work over the past year, I encourage you all to refer to the court's annual report, which aptly captures in detail the full scope of the court's achievement during that period. Before I close my address to you, indulge me as I take a moment to celebrate the new additions to our judiciary and to express my sincere appreciation and recognition of all those who have made meaningful contributions to the work of the Eastern Caribbean Supreme Court over the past year and beyond. I acknowledge those appointed to judicial office during the past year, whose acceptance of appointment reflects both professional distinction and a willingness to serve the public good. And so we warmly welcome the newly appointed Justices of Appeal, Her Ladyship the Honorable Petra Nicola Bayer, and Her Ladyship the Honorable Katie St. Rose Albertini, who have both commenced their new judicial appointments in this new law term. I welcome one of our newest long-term acting Justices of Appeal, His Lordship the Honorable Reginald Armour, who joined our court last year. I also welcome our newest High Court judicial appointees who joined us as of last year. Her Ladyship the Honorable Teresa Haddad, assigned to the territory of the Virgin Islands. Her Ladyship the Honorable Justice Sybil Sinat Dantes, assigned to St. Vincent and the Grenadines, as well as our newest Master, the Honorable Master Vernet Richardson. Each of you will no doubt bring valuable experience and perspective to our court, and I look forward to witnessing your further contributions in years to come. I am also particularly grateful to the judges and legal practitioners who have willingly accepted acting judicial appointments in the last year to serve as High Court judges, filling critical gaps in judicial capacity across our 9 member states and territories. I would especially like to recognize the more recently appointed acting judges who have committed themselves to long-term active appointments over the past year, including Her Ladyship, the Honorable Justice Akila Anderson, assigned to the territory of the Virgin Islands, Her Ladyship, Justice Sajela McDowell, assigned to the Commonwealth of Dominica, and Her Ladyship, the Honorable Justice Ingrid Mangatal Monroe, newly assigned to the High Court Commercial Division in the territory of the Virgin Islands. I am grateful to you all for your commitment and service to the court in times when your contributions are critically needed. This moment also calls for reflection and remembrance. Sadly, last year we lost important figures associated with the court, whose service and legacy have helped to shape this institution into what it is today. I wish to acknowledge the passing of Miss Evelina Batiste, daughter of the soil of Dominica, and sister to His Lordship the Honorable Davidson Kelvin Baptiste. Miss Batiste held many positions of service in this court throughout her distinguished life, having served as acting chief registrar of the ECSC, a former magistrate in Dominica, a former registrar of the High Court in Dominica, and the first female director of public prosecutions for the Commonwealth of Dominica. Her life was marked by obvious excellence, and we grieve her passing along with her family and loved ones. I also acknowledge the passing of Sir Gerald Watt, who was the most senior King's Counsel in Antigua and Barbuda and gave years of dedicated service to his country, both as a politician and cabinet minister. May his life of committed public service continue to inspire all of us. The court also mourns the passing of St. Lucia attorney and former magistrate Dr. Vellon John. His kind spirit, positive influence, and legacy have left an indelible mark on this court and the people of St. Lucia, and we too grieve the void of his loss alongside his family, colleagues, and friends. Finally, I acknowledge the passing of Mr. Christian John Arthurton II, who dedicated 25 years of his life to this court as senior bailiff in the Nevis Circuit in the High Court of St. Kitts and Nevis. His service and years of sacrifice for this court will not be forgotten. In recognition of a less grievous but no less heartfelt loss to this court, we also mark the retirement of the former acting Chief Justice, the Honorable Mario Michel, who took up the mantle to lead this court when his stewardship was greatly needed. We are grateful for his years of service to this court, which spanned over 15 years, having served as a High Court judge, Justice of Appeal, and acting Chief Justice. We wish him a happy and fulfilling retirement. We also wish a happy retirement to Justice Colin Williams, who served in the Commonwealth of Dominica and Antigua and Barbuda, and Justice Sean Innocent, who served in Anguilla, St. Lucia, and Grenada, both of whom retired over the course of last year. We are deeply grateful for their years of dedicated service and the lasting contributions which they have made to this institution. I also wish to extend heartfelt gratitude and warm best wishes to two long-serving members of our court headquarters family, the immediate past Administrative Secretary, Ms. Florentina Nelson, affectionately known as Joan, and our soon-to-be past Office Manager, Ms. Lena Sinqua. Their names are synonymous with the ECSC, each of them having committed over 20 years of dedicated service to this court, with Ms. Nelson concluding her service as of last December, and Ms. Sinqua being set to retire within the first quarter of this year. I applaud their professionalism and will feel the loss of the institutional knowledge they displayed in the execution of their respective roles. They will be deeply missed, and I wish them the very best as they move on to the next chapter of their lives. In closing, I must recognize and thank the many players who have helped make the proceeding year of the ECSC a success, and those who have committed to their continued service of the court for the advancement to come in this new year. To the appellate and high court judges, masters, and other judicial officers of the ECSC, I thank you for your diligent and dedicated service. Your service on the bench is critical to the court's capacity to fulfill its institutional obligations to the public, and the measure of your sacrifice is incalculable. To the management and staff of the ECSC headquarters and the constituent registries, your support and hard work on behalf of the judiciary has not gone unnoticed. We are grateful for the drive and dedication you show each day in keeping the wheels of justice turning. I extend special thanks to the ECSC Headquarters Information Technology team, who have gone above and beyond the call of duty to ensure the seamless technical execution of today's proceedings. Your work and support are vital to the success of this special sitting, and I'm grateful for your contributions. I also extend my appreciation to the OECS Bar Association and the constituent bar associations of the Eastern Caribbean for their continued cooperation and collaboration with the judiciary over the past year. I must also thank the commissioners of police and the police forces across the member states and territories for their continued protection which they provide to us, the judiciary. Finally, I would be remiss if I did not thank our external partners and donor agencies whose contributions have made much of the court's work over the past year possible through the funding that they provide. These partners and donors include the Government of Canada, the British High Commission, the European Union, UNICEF, UNDP's Project, the Justice Education Society, the University of the West Indies, and the OECS Commission. We also especially thank the governments of our member states and territories who have remained steadfast in their support of the court and its mandate. We are grateful for your partnership and your investment in the work of the Eastern Caribbean Supreme Court, and we look forward to a continuing and meaningful collaboration in the pursuit of justice. The endurance of the Eastern Caribbean Supreme Court has not been accidental. It is the product of careful constitutional design, judicial integrity, professional excellence, and the confidence reposed in the court by the peoples and governments of our sub-region. It is our duty as a judiciary, through renewed commitment, deepened focus, and clear understanding of our institutional responsibilities, to ensure that justice endures by honoring and strengthening the handshake of trust between the court and the public. Our institution has endured the last third of the 20th century, and we have successfully navigated the first quarter of the 21st century. I am confident that we will continue to endure evermore. I pray that Almighty God will continue to steadfastly guide our course, and may the Eastern Caribbean Supreme Court continue to deliver justice that endures, anchored in independence and strengthened through trust. I thank you.
Your Ladyship, the Honourable Chief Justice, Acting Margaret Price Finlay, Honourable Justices of Appeal, Honourable Justice of the High Court, permit me to stand on the protocol already established. Good morning and welcome to the official opening of the law year of the Eastern Caribbean Supreme Court 2026. I am Justice Zainab Jawara Alami, Senior Resident High Court Judge, Commonwealth of Dominica, and I have the honor of serving as your moderator today. I hail from the Little West African state of the Republic of the Gambia, and now in my second year of service with the Eastern Caribbean Supreme Court, and having survived unexpected torrential rainpours, fear of hurricanes, and the spirit and energy of Carnival, I can safely say I am now an adopted Caribbean. And I am honored to serve within this region and to engage with its long-standing legal and cultural traditions. We gather this year in the Commonwealth of Dominica, the nature island of the Caribbean, a jurisdiction known not only for its natural beauty and resilience, but also for its strong constitutional tradition and enduring commitment to the rule of law. It is especially fitting that we gather here today, given the last time Dominica was scheduled to host the opening of the law year, it coincided with Hurricane Maria, a devastating event that profoundly affected the nation. And in the years since, Dominica's recovery and resilience have stood as a powerful testament to endurance, stewardship, and the strength of its institutions. That very spirit resonates with our theme of justice that endures, anchored in independence and strengthened through trust. We are reminded by the Honorable Chief Justice that this annual ceremony holds special significance within our region. It marks not only the commencement of a new judicial year, but also a collective moment of reflection on the administration of justice within the Eastern Caribbean and the vital role played by the court in safeguarding the rule of law across our member states and territories. As the Honorable Chief Justice has also highlighted, this new law year begins in a time of continuing legal and societal changes. Issues of access to justice, efficiency, technological advancement, and the protection of fundamental rights remain central to our work. These challenges call upon all officers of the court, judges, practitioners, and the court staff alike to renew our commitment to excellence, integrity, and service. As moderator, my role is simply to guide the proceedings and facilitate the orderly presentation of the program. And it is therefore my distinct honor to invite the Attorney General, the Honorable Mr. Levi A. Peter, to deliver his address. Mr. Peter.
Your Ladyship, the Honorable Madam Margaret Price Finlay, Acting Chief Justice, Justices of Appeal, Judges and Masters of the Eastern Caribbean Supreme Court, permit me to adopt the protocol as already established. It is my distinct honor as Attorney General of the Commonwealth of Dominica to address this special sitting of the Supreme Court, marking the opening of the law year 2026. This occasion is not merely ceremonial. It is a moment for sober reflection on the centrality of the rule of law to our democratic governance and on the shared responsibility borne by all institutions of the state, and indeed the region, to its effectiveness, credibility, and legitimacy. At the outset, I extend on behalf of the government and people of Dominica sincere appreciation to the honorable judges of the Eastern Caribbean Supreme Court for the independence, dedication, and professionalism with which they continue to discharge their constitutional mandate. In an era characterized by increasing legal complexity, expanding caseloads, and heightened public expectation, the judiciary has remained steadfast in its commitment to justice, restraint, and fidelity to the law. I also wish to acknowledge the indispensable contribution of our magistrates, registrars, court administrators, and support staff. Their often unseen but tireless work sustains the daily operations of our courts, and it's fundamental to the effective delivery of justice. I am advised that the past year has witnessed meaningful progress across our justice system, improvements in case management, greater utilization of alternative dispute resolution, and continued judicial education and training across the OECS have contributed to enhanced efficiency and greater consistency in decision-making. Legislative initiatives aimed at modernizing criminal procedure, strengthening regulatory frameworks, and improving access to justice have further advanced a more responsive and contemporary legal architecture. Candor, nonetheless, requires acknowledgement that significant challenges persist. Case backlogs, trial delays, infrastructural constraints, and critical shortages in court support services, most notably perhaps in transcription, continue to affect the timely delivery of justice. These are not abstract or technical deficiencies. They have real consequences for victims seeking closure, for accused persons awaiting trial, and for the public confidence in the justice system as a whole. At the same time, the evolving nature of legal disputes, particularly transnational crime, financial and economic offenses, cyber-enabled wrongdoing, and increasingly complex regulatory litigation, demands new skills, updated laws, and deeper regional and international cooperation. No single jurisdiction can meet these challenges in isolation. The strength of the Eastern Caribbean Supreme Court lies precisely in its regional character, shared standards, and collective experience. Against this backdrop, I wish to confirm, as Attorney General, the government's firm commitment to supporting OECS-wide judicial reform and national initiatives aimed at strengthening the administration of justice, while fully respecting and upholding the constitutional independence of the judiciary. The achievement of a justice system that is more efficient, resilient, and responsive rests on three connected pillars, I would suggest. One, continued modernization of the justice system, including digital transformation, improved caseload management, and procedural efficiency. Two, sustained institutional collaboration among the judiciary, the bar, the legislature, the executive, and regional partners, grounded in mutual respect and a shared commitment to reducing delay and enhancing access to justice. And three, investment in people through judicial education, professional development for legal practitioners and court staff, and the promotion of ethical leadership across the justice sector. The way forward, therefore, demands partnership, respectful, constructive, and principled among the judiciary, the executive, the legislature, the bar, and civil society. The rule of law is not the responsibility of any single institution. It is a shared national and indeed regional trust. Before concluding, I wish to mention the issue of ethics and professional regulation. A strong, efficient justice system cannot exist without a disciplined, ethical, and accountable legal profession. Regrettably, instances of professional misconduct, and in some cases outright dishonesty, by a small minority continue to undermine public confidence and tarnish the reputation of this noble profession. For far too long, Dominica's efforts to enact comprehensive legal professional legislation have been deferred, often overtaken by competing priorities and constrained resources. I can, however, confirm that a draft Dominica Legal Profession Bill is currently receiving focused and sustained attention, including careful consideration of substantive recommendations advanced by the Dominica Bar Association. It is anticipated that a bill will be available to be tabled before the House of Assembly by the end of the first quarter of 2026, with the objective of modernizing professional regulation, strengthening disciplinary mechanisms, and aligning Dominica with regional best practice. As we commence the law year 2026, let us recommit ourselves, nationally and regionally, to a justice system that is timely, accessible, and worthy of public trust. The strength of our democracy depends not only on the laws we enact, but on efficiency, integrity, and independence with which they are administered. I extend best wishes to the Honorable Court and to the entire legal profession for a productive and successful law year, and I thank you for your continued service to the people of the Commonwealth of Dominica and the wider region. I thank you.
Thank you, Attorney General, for highlighting the important and significant partnership between the Eastern Caribbean courts and government, and in upholding the rule of law, and most particularly the significant progress made in the passing of the long-awaited Legal Practitioner Act. At this point, we now turn to the prosecutorial perspective within the justice system, and I call on the Director of Public Prosecutions, Ms. Sharma Dalrymple, to address the gathering.
May it please you, Honorable Madam Chief Justice, and the Justices of Appeal, and the Justices of the Eastern Caribbean Supreme Court. I wish to establish the protocol already established in these proceedings. I wish to start my address this morning with the simple quote: "If we desire respect for the law, we ought to make the law respectable." I will repeat for emphasis. If we desire respect for the law, we ought to make the law respectable. A very simple statement, which by the end of my short address, I hope everyone remembers during and beyond this law term. This maxim was stated by Justice Louis De Brandis, an Associate Justice of the U.S. Supreme Court. This maxim was enunciated several decades ago and means simply, if we require the law to be respected, we ought to ensure that we make the law respectable. We, custodians of the legal system within our OECS states, must ensure that justice and equality are meted out by our laws, and then also ensure that there is a constant evaluation and refinement of legal frameworks to ensure that they align with evolving societal problems and societal norms, and the society is knowledgeable of the law. Let's consider our social context that our small states are now facing. Instances of gun violence run as a disease within our states. Times of festivities, carnival, Christmas, village feasts, community cultural events have the dark shadow lurking of a gun crime being perpetuated. The news and social media regularly bring shockwaves in our communities with stories of violent gun-related offenses. Phrases such as double murders, man gunned down, shooting claims the life of, police investigating the shooting death of, young man in critical condition after sustaining gunshot wounds are plastered on the media way too often in these times. OECS member states have robust legislative frameworks in respect of firearms offenses, be it the Firearms Acts, anti-gang legislation, and also sentencing guidelines which make provision to be deterred from with good reason. However, we ought not to be sidetracked and put the blame only on members of society and not us. We ought not to jump to the conclusion that individuals don't respect the law. Consider, are we making the law respectable? Are we, as administrators of the justice system, advocating against the plague which is affecting our small island states? Do we feel insulated because we live in our upscale communities and gated communities? Do we feel insulated because we work in our air-conditioned offices and we do not do any criminal law? Do we feel protected as because of the position we hold in the administration of justice, we are secured by an armed officer? Do we have the notion that the police have their work cut out for them, or the police are not doing enough? Is this the job of the police only? Haven't we forgotten in 2014, senior counsel Dana Sitahal was gunned down in Port of Spain on her way home? Haven't we forgotten that on New Year's Eve 2024, attorney-at-law Special Prosecutor Randall Hector, at the age of 43, was shot and killed after coming from church? This happened in the presence of his wife and children. I plead with you, colleagues, with you honorable judges, with court workers, court administrators, defense counsel, prosecutors, to fully understand what we have to make the law respectable. We have to take a stance against the senseless killings in our small island states. We have to make the law be respected. Bar associations need to speak out. The public ought to be educated by attorneys on the law and the repercussions of breaches of the law. The court needs to take a clear stance against these violent offenses and apply the law. It is a unified approach, which I know that we can do. We have to be active participants in the process. We can't wait until it reaches the courtroom. When an accused is before the court, by this time, a life has been taken, a family is grieving, and an individual's liberty is at stake. We can't sit in the comfort of our bar association meetings and don't bring up these societal problems. Are we to continue attending OECS conferences and meetings and not consider that we ought to start to put proper protocols, guidelines, and new laws in place to deal with these problems? We have been trained that the law commands respect. The laws of the land are to be respected, but we, as the custodians of the law, ought to make the law respectable. We need to be in active pursuit and not leave it up to society to only do the enforcing of the law. Colleagues, we should actively participate in shaping the legal framework to deal with societal problems. I do hope that my short statements has not brought an atmosphere of gloom today. It was my only intention to convey to you that we have to understand the problems which exist and that the law ought to evolve to deal with these problems. Our beautiful small island states, with our rich cultures, our high values, and beautiful landscapes are under attack, and we embody a force that can cause change. We are the ones who can make the law respectable. This is the only way that the rule of law can be maintained. Honorable Justices of Appeal, Justices of the Eastern Caribbean Supreme Court, these are the extent of my speech this morning.
Thank you very much, Honorable DPP, for those remarks and for highlighting the need to make the law respectable by collective action to uphold the rule of law. The administration of justice at the summary level remains a vital component of public confidence in the legal system, and it is therefore my honor to invite the Chief Magistrate, Her Honor, Mrs. Candia Carrot George, to address the gathering.
Good morning, everyone. Her Ladyship, the Honorable Mrs. Margaret Price Finley, Chief Justice, Acting, Justices of Appeal, Judges, and Masters of the Eastern Caribbean Supreme Court. I acknowledge your presence here this morning. Please allow me to adopt the protocol that has already been established. It is indeed a great pleasure to present this report on the activities of the Dominica Magistrates Court for the year 2025. The year 2025 indeed had its challenges, but we were able to successfully navigate through them. Allow me to share a few of our highlights. Staffing, appointments. I am pleased to report that during the latter period of 2025, we saw the addition of 3 magistrates. Ms. Marie-Louise Pierre-Louis took her oath of office in October. Ms. Pierre-Louis was previously attached to the Office of the Director of Public Prosecutions and brings her experience in criminal law. She has been assigned primarily criminal matters. Ms. Pelissa Morvan took her oath in November. Ms. Morvan joins us from the Attorney General's chambers and will preside over case management hearings, civil matters, and coroner's court, in addition to other case types. Ms. Kimala Alfred was sworn in as a magistrate in December. Ms. Alfred was previously attached to the Legal Aid Clinic. Ms. Alfred will preside primarily over family and criminal matters. I welcome each of them and extend well wishes to them as they take up their new roles in the magistracy. The addition of these magistrates represents a major step toward improving court efficiency and effective case management, with the main goal being the reduction of the case backlog and the effective and timely disposition of matters. The total number of magistrates now stands at 8, which represents a full complement for Dominica. Bereavements. In September of 2025, we sadly lost Mr. Philip Daniel, who for a number of years was employed as a bailiff with the Magistrates Court. Mr. Daniel worked with us at both the Roseau and Portsmouth court offices and did a formidable job in ensuring that summonses were served. We will surely miss him. Resignation. In August of 2025, Magistrate Pearl Williams resigned to take up an appointment in a sister jurisdiction. She has worked at the court for the past 9 years. I wish to place on record my thanks to Ms. Williams for her years of service to the Commonwealth of Dominica and wish her well with her new assignment. Mrs. Natasha Pondyok, who served as court administrator with 30 years of experience at the Magistrates Court and a track record of efficient and valuable service, has, after a period of vacation leave, resigned from the position as of December 2025. We wish Mrs. York well in her future endeavors. Equipment and modernization. In 2025, under the United Nations Development Program, PACE Justice Project, equipment including 14 laptops and 14 printers were received. The machines and accessories have since been installed and are in use at the various magistrates' courts. Additionally, 2 digital Liberty recording systems were received. The systems will be installed sometime next week. Our thanks to the UNDP for their continued support of the Magistrates Court. We look forward to future collaborations. Training. In July of 2025, magistrates attended a 5-day workshop to build capacity among the region's judiciary in anti-money laundering, counter-terrorist financing, and counter-proliferation financing. The workshop was hosted by the Eastern Caribbean Central Bank, ECCB, in partnership with the Regional Security System. In September of 2025, magistrates and supporting staff, along with other stakeholders, attended a 2-day PACE Justice-sponsored case management workshop for magistrates, registrars, judicial assistants, and clerks of court. The workshop highlighted various tools and techniques which will help in effective case management. We are grateful for these training sessions. Statistics and court schedule. During the year under review, a total of 3,765 matters were filed at the Dominica Magistrates Court, while 2,053 were disposed of, thus realizing an increase in our backlog of cases, sadly. With the addition of our new magistrates, it is my hope that by this time next year, I will be able to report a decrease in the backlog of cases, as with the engagement of the additional magistrates, an increased number of courts will be sitting simultaneously. It is worth noting that night court sittings were reintroduced in September of 2025. The night court sits from 2 p.m. to 9 p.m. Mondays to Thursdays and hears mainly private criminal and civil matters. Case management hearings will begin this month, January 2026. These hearings will serve as pre-trial hearings, where the presiding magistrate will assess case readiness before the case is scheduled for trial. The suitability of matters for hearing before the night court will also be determined at these hearings. Through this new initiative, judicial time will be saved, as only matters which are ready for trial will be listed, thus reducing the need for excessive adjournments. The Coroner's Court currently convenes 3 times per week, that is on Mondays, Wednesdays, and Thursdays. A dedicated courtroom has now been established to facilitate daily sittings of the Coroner's Court Mondays to Fridays. This is in an attempt to accelerate the completion of inquests and facilitate quicker disposition of these matters. We currently have problems in securing jurors for Coroner's Court and in the service of summons for this court. It is my hope that with the daily sittings, new strategies can be put in place to attract persons to serve as jurors, and that the police will put more effort into serving of summons so as to ensure that the increased sitting is not an exercise in futility. Our current infrastructure work continues on the new court buildings at Grand Bay and St. Joseph. My gratitude goes out to the Honorable Minister for National Security and Legal Affairs, the Honorable Mr. Rayburn Blackmore, the Permanent Secretary, and other auxiliary staff of the Ministry of Legal Affairs for the invaluable support provided to the magistracy and its operations through 2025. I also wish to acknowledge the continued hard work of the magistrates and the court staff who provide the necessary support for the effective administration of justice. Finally, I remain grateful to God for His grace that has carried us through 2025 and will continue to be with us as we navigate through 2026. I wish everyone a successful law year. As the Eastern Caribbean Supreme Court provides justice that endures, may we all remain anchored in independence and strengthened through trust. If it pleases your lordships.
Thank you, Mrs. Carrot George, for those remarks and for underscoring the essential role of the magistracy in the effective delivery of justice, as well as the significant initiatives introduced in the year 2025 with the aim of reducing the backlog of cases. We now turn to the regional perspective of the legal profession, reflecting the integrated and regional character of the Eastern Caribbean Supreme Court. And it is my honor to invite the president of the OECS Bar Association, Mr. Delano Bart, King's Counsel, to address the gathering.
Your Ladyship, Chief Justice Acting, Ms. Price Finley, may I seek your permission to adopt the protocol that you have so established beyond your name. May I also thank you for the rather comprehensive report that you gave to us
in terms of the activities of the court. May I also express my gratitude to you that I am able to address you and this court in my capacity as the president of the Eastern Caribbean Bar, the organization of the Eastern Caribbean Bar, and making certain comments in respect of this year under the title Justice That Endures, Anchored in Independence Strengthened Through Trust. This opening comes at a time when the future of the world, particularly our region and our institutions, are being stress tested. This year's theme is reflective of the past and shows how we got here, and no doubt it expresses our aspirations that this court will continue to guarantee those for our future. There is no doubt that this is an environment, in this environment, it will prove challenging, but the important thing that we must do is not fail. We must hold our nerve. It was once felt that our institutions held our societies together, but the evidence and history has shown that it's not just the institutions so much, but more the individuals that hold those offices in those institutions that sustains our society. In other words, the character of those are equally and perhaps even more important than the institutions which they hold. For us, the rule of law has been fundamental to our society. Due process is also part of the backdrop to our concept of justice. We have seen elsewhere where both the rule of law and due process has been replaced by arbitrary justice, leaving members of their society weakened and betrayed. We have seen judges and prosecutors of the International Criminal Court sanctioned for discharging their duties according to the law. There is no doubt of the impact that that has had on individuals. It would be wise for us to assume that it can happen here, and it may happen in the worldwide and also here. In our case, it could be the simple dissatisfaction of a court decision. It may come as an act of disapproval in respect of the decision a government may make, but yet the court may find itself having to bear the consequences of that. There also can be subtle methods of disapproval, delayed support from certain quarters, and artificial reasons for not lending support in other areas. Among the functions and objectives as founded in the Constitution of the OECS Bar is our duty to promote the administration of justice, support the independence of the judiciary, express the collective opinion from time to time in support of the judiciary. The Bar continues to support the rule of law and due process, both in regards to the domestic and international law. The Bar therefore recognizes its duty to do all that are incidental and conducive to the attainment of those objectives. The Bar therefore shall remain supportive of the court wherever there is a threat to the rule of law and due process. I turn now to another matter. Yes, this morning I've heard some things which have certainly been good in terms of that context, and that it's in relation to the tenure of judges. But there are two areas that concern the Bar. The first is that over the years, our governments have acted in a way which calls for us at this stage perhaps to require them to revisit the Supreme Court order and all the relevant legislation that are concerned with the appointment of our justices. It is not enough simply to say that it's a difficult task, as that there must be a way out. When drafting the instruments for the establishment of the Caribbean Court of Justice and the appointment of the president of that court, the drafting committee studied the appointments of the chief justices of the Eastern Caribbean Court. They noted the delays and the reasons for the delays in making those appointments at times and the delays in doing so. They noted also the consequential continued lengthened periods that justices have been forced to act as chief justices. It is a position that is not good as a model to be followed, and so they recommended an alternative model. It is time for us to look at our model and address it in this matter. I raise this because it is time we do so. Failure to do so will eventually damage the confidence that is necessary in the appointment of the Chief Justice of our institution. I was also happy to hear of the additional appointments of High Court judges, but yet your ladyship did point to some short-term appointments. One understands that, but too often one gets members of the bar receive information indicating the appointments of justices for rather short periods. That, in my respectful submission on behalf of the bar, undermines the independence of the judiciary. If there is anything that we can do, whether it concerns the question of conditions of employment, conditions of appointment, that can make it more attractive and so that we do not have this ongoing state of affairs, we at the OECS Bar would be willing to be of assistance. I, as you are aware, my lady, was recently appointed the president of this august body. It has humbled me, and I appreciate that much is expected of me. I intend to do my best, and I do pay tribute to the past president, Ms. Jean Dyer, who made a sterling contribution to the association. She has provided a solid base upon which much can be built. Her signature event, the annual law conference, will continue, and she will continue to play and be involved in it. Your Ladyship, Hurricane Melissa provided a challenge for all of us, and I'm happy to say that the Eastern Caribbean Bar was able to bring the different constituent bars together to raise finance in support. Through the coordinated efforts, we were able to raise nearly $75,000, which we forwarded to the Jamaican Bar to assist, for their assistance. We have asked the Jamaican Bar to provide us with evidence of the way that the funds have been used. They have promised to do so in due course. But it's not as simple as that. That was a consequence of the request of many who made contributions that they would like to know what was the outcome and with the way the funds were dispersed. And it's also important because we felt it was necessary to follow through on that request because we know that it can impact, or failure to have a response or accountability can have an impact upon future requests for support and donations. We would like to thank all the bars for their contributions and to the individual firms that have made contributions. Special mention, however, must be made of the Antigua Bar, which brought in sums substantially in excess of the minimum request was made of them. In terms of ongoing activities, we have been fortunate to have just begun, as it were, some discussions with the Canadian Bar and institutions, the Bar of Canada, who have offered us to provide training, advocacy training for advocacy training skills and in litigation in respect of our bar here. We are in active discussions on that, and it's in a preliminary stage, and as soon as that is completed, we will roll it out to the bar for the purposes of discussions and the finalization of the details. In terms of continuing legal education, my lady, it is an ongoing issue for us, and we have had many challenges in the effort to coordinate it, but that is one of the things that continues to be on our agenda, and we will pursue that. I'm also happy to advise, as the court is aware, that we were able to find a nominee for the Silk Advisory Committee, Mrs. Anne Henry Casey of Antigua, and we're sure that she will certainly make a major contribution to that. Just before closing, I'd like to indicate that there are two issues that continues to plague the OECS Bar. The first is that of an archive system. We have been in existence for nearly 35 years, but in terms of the earlier parts of its existence, it's extremely difficult to find that material. And so we will seek to embark upon an exercise to try and collate as much as we can. I suspect that the court itself has quite a bit of information. I do recall that a speech which was made by the acting Chief Justice Maria just before he left catalogued in a substantial detail quite a lot of that historical background, and we may therefore be looking to the court for assistance on that matter. In terms of the rather nomadic and perhaps bohemian existence of the OECS Bar, i.e., it has no place of abode, it has no headquarters, and that is something that we are going to seek to try and address at some point in the... It's important because at the end of the day, the need for supportive staff and at least a place to look for would be ideal in respect of the continued existence. What happens is that when you have a new president or a new treasurer or secretary, the details and the information goes with that secretary, and it may not reach, it begins with one, and they may not collate the existing information that is elsewhere, and so that is something that we'll have to look. We also note the court-connected mediation in criminal matters, and we saw the discussion papers, we responded, as some of us have, and we are grateful for the initiative, and we will support it. In closing, we wish to thank the court for the opportunity to address it. We wish you both a healthy and productive year, and we know that the many challenges which you have in the new year, you will arise to meet those. Thank you very much.
Thank you very much, Mr. Delano Bart, for those remarks and for offering a regional perspective on the role of the bar in upholding the rule of law and in highlighting the duty to promote the independence of the judiciary and the need to revisit the Supreme Court order on the tenure of judges to promote confidence in the court. We now invite the perspective of the organized bar at the national level, whose members play a central role in maintaining professional standards and strengthening public trust. I invite the president of the Dominica Bar Association, Mrs. Noelise Knight Didier, to address the gathering.
May it please your lordships and your ladyships, the Honorable Chief Justice of the Eastern Caribbean Supreme Court Acting, Madam Margaret Price Finlay, Honorable Justices of Appeal, Honorable Judges of the High Court, good morning. With your leave, I just wish to acknowledge and greet the Honorable Attorney General, Mr. Levi Peter, and the Honorable Minister for National Security and Legal Affairs, our Minister, Mr. Rayburn Blackmore, and all other distinguished dignitaries and guests as mentioned in the protocol list established by Her Ladyship, the Chief Justice. My lords, my ladies, it is both an honor and a privilege to address this special sitting of the Eastern Caribbean Supreme Court, marking the opening of the law year 2026 on behalf of the Dominica Bar Association. It is even more so a privilege given that this is the first time in recent memory that the official ceremonial opening with the Chief Justice's address has been here in Dominica. We recall, of course, as indicated by Justice Jawara Alami, that the plans for the last scheduled sitting of this nature was in 2017 and were, as we say locally, kiboshed by Hurricane Maria. My lords, my ladies, the theme selected for this year, the Eastern Caribbean Supreme Court, justice that endures, anchored in independence, strengthened through trust, is timely and deeply resonant. While judicial independence is the bedrock upon which our system of justice rests, it is trust that gives that independence life, meaning, and legitimacy in the eyes of the public that we serve. This morning, my lords, my ladies, I wish to focus particularly on trust, how it is built and sustained, and why a justice system that works well is the surest foundation for public confidence. Trust in the justice system does not arise from lofty ideals alone. It is earned through lived experiences. People trust a system when it is accessible to them, when it is efficient, fair, and when it delivers timely and reasoned outcomes. They trust it when their matters are heard without undue delay, when judicial officers are adequately supported, and when the administration of justice is seen to be responsive rather than remote. For this reason, the responsibility of nurturing trust cannot rest on the judiciary alone. It is a shared enterprise. We have heard a lot of that this morning. It belongs equally to the bench, the bar, the executive, the court staff, and all stakeholders who play a role in the administration of justice. When each arm of justice system works collaboratively and in good faith, the system itself works better and the trust naturally follows. While we would have liked to see some more dialogue between the Bar and the Ministry of Legal Affairs over the last year, I wish to nevertheless publicly acknowledge some of the meaningful strides made by the Ministry of Legal Affairs in strengthening the administration of justice in Dominica over the past year or two. I would say also that when there has in fact been dialogue, this has proved constructive and productive. One of the major calls that had been made by the Bar to the Ministry was for the appointment of more magistrates. And we are pleased, as indicated by the Chief Magistrate, that over the past few months, 3 new magistrates have been appointed, and for the first time in a very long time, we now have the full complement of magistrates appointed. Kudos to the ministry. We also acknowledge the appointment of one of the magistrates as a case manager and the planned installation of the Liberty recording system in the magistrates' court. My lords, my ladies, the case management initiative is actually a manifestation of the positive effect of consultation, because this idea was born out of a consultation, albeit belated, but a consultation among representatives of the ministry, the magistracy, and the bar regarding the introduction of night court. My lords, my ladies, we are sure that these and other recent measures taken by the ministry will directly and positively impact the administration of justice within the magistrates' court and help to build the confidence of the public in the courts. My lady, my lords, my ladies, and my lords, while the number of magistrates has increased, we were sorely disappointed to learn of the departure of the Honorable Justice Davidson Baptist, who made significant strides in addressing the severe backlog of caveat and other land disputes in our jurisdiction. Some of these matters dated back 10 to 20 years, and finally they were either disposed of or on their way to being disposed of, thereby restoring the trust and confidence of these litigants in the justice system. On behalf of the bar, I wish to publicly thank Justice Baptist for his work, and to thank, of course, the Ministry of Legal Affairs, the court, and the JLSC for his appointment. Further, however, we make a plea for his return. We can find the money, Mr. Minister. We ask for his return or at least the appointment of another suitable judge in his stead. We wish to maintain the momentum of addressing these caveat matters and also the several other civil court matters that face delays at the trial stage. Our local resident Justice Jawara Alami, her desk is full. It is full. I know she needs some help. My lords, we have 3 physical courts, and we do wish to utilize them all. The Dominica Bar Association has itself sought over the past year to play its part in strengthening trust in the judicial system. And I wish to thank the executive and members for their work and support in this regard. As the organized voice of the legal profession, the bar has remained committed not only to the interests of its members, but also to its broader public duty of outreach and engagement on critical issues. Over the past year, the executive ensured timely issuance of statements and comments on matters such as electoral reform, attacks on the judiciary, and public demonstrations. On the latter, we also held a public panel discussion on the constitutionality of the Riot Act, the ancient Riot Act. In addition to its advocacy, the bar extended its community outreach beyond the courtroom through a prison visit during our Law Week activities, and also through the Voices of the Bar Choir, who visited homes for the aged during the Christmas season, bringing encouragement and Christmas cheer to residents there. Alongside its public advocacy and outreach, the association has also prioritized the professional development of its members, recognizing, as indicated by Her Ladyship, the Chief Justice, that public trust in the judicial system is inseparable from public confidence in the legal profession itself. Continuing legal education is essential. The main CLE event put on by the bar in 2025 was a Title by Registration Act 2-day masterclass. This provided both practicing attorneys and law students practical insights and interactive discussions on this important area of everyday legal practice. Speaking of public confidence in the legal profession, my lady, we must acknowledge that the bar came under some heavy attack from some members of the public in recent months. This highlighted once more the need for the urgent passing of the Legal Profession Act. The most recent iteration of the draft bill was reviewed by the Bar Association, and we submitted our final report to the Attorney General early last year. We now await his feedback, and are very pleased to hear this morning from the Attorney General that the bill will be introduced during the first quarter of this year. My ladies, my lords, looking ahead, one of the most significant initiatives proposed by the Bar Association for the coming year is a National Justice Symposium, envisioned as a 2-day forum bringing together all stakeholders in the justice system. The proposed symposium would provide a structured space for candid solutions, dialogue on both criminal and civil justice systems. My ladies, such a symposium has the potential to be transformational. It would allow stakeholders to identify systematic challenges, share best practices, and develop practical recommendations grounded in realities. We hope that during this symposium, the Needham's Point Committee can come out of it. We do not have one, and we really hope that out of that, we will be able to establish it. More importantly, such a symposium would reinforce a culture of collaboration, signaling to the public that those entrusted with the administration of justice are willing to engage in honest self-reflection and collective problem solving. When people see cooperation rather than conflict among justice actors and reform rather than defensiveness or inertia, trust is strengthened. My lady, as we open the law year 2026, let us therefore recommit ourselves to the shared goal of making our justice system work effectively, efficiently, fairly, and work in the service of the people of the Eastern Caribbean. In doing so, we ensure that the Eastern Caribbean Supreme Court remains not only anchored in independence, but strengthened through trust. On behalf of the Dominica Bar Association, I wish to extend to you, the judiciary, and to all officers and staff of the court for the lawyer 2026, the very best for the lawyer 2026. Thank you, if you please support.
Thank you, Mrs. Knight Didier, for those remarks and for highlighting the advantages of dialogue amongst stakeholders in the justice system, and the need for collective action to achieve the objective of a better working justice system. On that note, we now turn to the perspective of experience within the legal profession, and it is my pleasure to invite Mr. David Bruni to address the gathering.
Good morning. Good morning. Honorable Chief Justice and members of the judiciary. Honorable Chief Justice, I would seek your permission to adopt the protocol already established before this gathering. Thank you. We gather here today with humility and gratitude at the opening of this new law term, mindful that all wisdom, justice, and authority flow from Almighty God. It is fitting that we begin this term by seeking His guidance, acknowledging that unless the Lord builds a house, those who labor build in vain. This ceremonial opening reminds us that the practice of law is not merely a profession, but a calling, one that carries with it immense responsibility. The scriptures teach us in Micah chapter 6, verse 8, "What does the Lord require of you but to do justice, to love mercy, and to walk humbly with your God?" These words speak directly to the heart of our work as judges, magistrates, and legal practitioners. The law serves as the moral compass of our society, safeguarding rights, preserving order, and ensuring fairness for all. As officers of the court, we are entrusted with the sacred duty of upholding justice, often in circumstances that demand courage, wisdom, and compassion. In carrying out this duty, we must remember that justice devoid of mercy can become harsh, while mercy without justice can erode the rule of law. It is the balance of both that sustains a righteous society. As we commence this law term, we are conscious of the challenges facing our justice system. Delays, increasing caseloads, as our civil judge is experiencing, increasing caseloads, and the evolving needs of our people. We therefore pray for clarity of mind, sound judgment, patience, and integrity for all who serve within the courts. We also pray for those who come before the courts, and that they may encounter fairness, understanding, and hope. I wish to recognize the dedication of the judiciary, particularly our judges, and the judges who've recently been on the bench. Court staff, members of the bar, whose daily labors are often carried out quietly and without recognition. Your commitment reflects a deep respect for the rule of law and for the communities we serve. At this juncture, I'd just like to speak a little about the judges who actually work within our justice system in Dominica. We've had recently Honorable Justice Colin Williams, and I appeared before him on numerous occasions as a criminal practitioner, and it was enjoyable appearing before him. He reminded me of the late great Justice Dunbar Sinnock, who I spent the first year of practice appearing before. And Justice Dunbar Sink always told me, counsel, listen carefully to your judge. Your judge is guiding you in the right direction. I learned so much from Honorable Justice late Dunbar Sinnock, and I had a similar experience with Honorable Justice Colin Williams. Every time I appeared before him, he enhanced my understanding of the law. He brought his experience from the DPP's office to bear, and I remember always encouraging the young lawyers to go and appear before him, because every time I appeared before Justice Colin Williams, I learned immeasurably. And you learn from experience, the experience he had for, I think, 30 or 35 years in the DPP's office. You can't match that experience. And I hope and pray that he's not lost to us, because he made a profound impact on my practice. And the same goes for our civil judge. And I have to say that she's made me a better civil practitioner. And I know her attention to detail and the edginess she brings to her court. You see, it's always good to be on edge before a judge. You're laughing. There's the assurance of preparation. And our civil judge runs her court in an efficient manner that ensures that we are prepared and things get done. Nothing is, the adjournments are rare. So I thank you, Madam Civil Judge. I thank you. Okay, and I won't be much longer, but okay. So to my colleagues at the bar, let us conduct ourselves with civility, respect, and ethical discipline. Let our advocacy be firm yet fair, and our dealings marked by honesty and courtesy, remembering always that we are servants of justice first. As we open this law term, may God grant us the wisdom of Solomon, the courage of Esther, and the integrity of Daniel. May our courts remain places where truth prevails, rights are protected, and justice flows like a mighty river. I pray that this law term will be guided by peace, cooperation, and mutual respect, and as our collective efforts will continue to strengthen public confidence in our great profession. Thank you.
Thank you very much, Mr. Bruni, for those reflections and for sharing insights drawn from years of professional service. And most importantly, thank you for acknowledging our efforts as judges in the administration of justice. I am pleased to know that my efforts are working. We now invite the perspective of the next generation of the bar, whose contributions will shape the future of the legal profession and the administration of justice in the Eastern Caribbean. It is my honor to invite Ms. Shanice Henry, junior member of the bar, to address the gathering.
Good morning. Madam, Your Ladyship, Honorable Chief Justice, permit me to stand on the protocol already established. Thank you. Good morning, everyone standing here today. I'm honored to address you today on behalf of the junior members of the bar at the opening of this new law year. Under the theme, Anchored in Independence, Strengthened Through Trust. Independence in our profession is not something that we arrive with. It is something that we develop. It is shaped through experience, discipline, and exposure to good practice. For junior attorneys, independence grows not in isolation, but alongside guidance, accountability, and example. Independence is strengthened through trust. Trust from senior members of the bar looks like guidance that is intentional and constructive. It looks like teaching that goes beyond instruction, mentorship that explains not only what is done, but why it is done, and professional respect that recognizes junior attorneys as developing practitioners rather than mere assistants. Where that trust exists, independence matures with confidence and competence. Trust from the judiciary plays an equally important role. For junior counsel, and I say this very humbly, it is reflected in engagement that is fair, patient, and clear. Patient, most importantly. When the bench allows junior counsel the space to be heard while holding them to proper standards, it strengthens advocacy and contributes meaningfully to professional development. In doing so, it reinforces the integrity of the judicial profession itself. This is reflected in our jurisdiction by the appointments of junior members to the magistracy. They stand as reminders that when independence is properly cultivated and trust is meaningfully extended, the profession is strengthened. Trust from the public is perhaps the most demanding. For junior attorneys, it requires conduct that is ethical, prepared, and principled at every stage of practice. Public confidence in the legal system depends on the belief that all attorneys, regardless of seniority, act with integrity and respect for the rule of law. Each appearance before the court carries that responsibility. As we begin this law year, junior members of the bar do not seek exemption from high standards. We welcome them. What we value is independence that is properly formed, trust that is meaningfully extended, and professional relationships that recognize that the strength of the bar depends on how its newest members are developed today. On behalf of the junior members of the bar, we recommit ourselves to diligence, integrity, and service. We enter this law year ready to learn, ready to contribute, and ready to uphold the honor of this profession. May this year strengthen our independence, support the trust that allows it to grow, and advance the administration of justice. Thank you.
Thank you, Ms. Henry, for those remarks and the reminder for professional respect, mentoring by senior counsel of juniors, and the need for professional development for the strength to advance the rule of law. As today's addressees have demonstrated, the theme of this law year is not aspirational alone. It is a shared responsibility. Independence must be preserved, trust must be earned, and justice must be allowed to endure through consistent principled action. Thank you all to our speakers for their thoughtful and measured contributions, which together reflect our shared commitment to justice that endures, anchored in independence and strengthened through trust. And on that note, I wish to make an announcement about the public lecture tonight. I would like to take this opportunity to remind all attendees present this morning to attend the ECSC public lecture scheduled for this evening at 6 p.m. at the State House Conference Center. The lecture will address estate planning and access to justice and will be delivered by the Honorable Justice Alvin Pariaxing. A cocktail reception will follow immediately after the lecture. Thank you all.
All stand. This honorable court stands adjourned until Tuesday, the 13th day of January at 9 o'clock a.m. I command of this court, God save the Commonwealth of Dominica and its honorable court.